Yeah, I know. Worst case, it'll help us. I'm telling you. I was right. I was influenced.
All right, court is calling 2021 CR 7554, State of Texas versus Aaron Trevino. Now parties announced for the record for the state.
Michael Villarreal and Ruben Herrera for the state.
Defense.
Also providers for the defendant, Aaron Trevino.
All right, and are you Mr. Trevino? All right, so my understanding, the court is in receipt of the discovery acknowledgements. The supplemental and the original one. The original discovery acknowledgement is dated from July 27, 2022. And I received a supplemental discovery dated today. Defense, have you received all the discovery?
I have, Your Honor.
All right, the court will find that the state is in compliance with discovery. Defense, have you filed an election?
Yes, Your Honor, we have. And that election, it is to the jury, Your Honor.
All right, Caroline, do you have the?
I don't know if you have to follow.
Yes, and I don't see one in here. Could you file another one, counsel?
On May 3rd.
If you'll just file the one, because the e-file, it's somewhere in the system.
The universe.
Yes, if you could just file one. And there should be a document over there.
Thank you.
All right, and then it's the court's understanding that states you're proceeding on the indictment as presented. Is that correct?
That's correct.
Just one moment. So the court has the indictment, and the indictment is without the repeater count. So is that something that the state filed a motion on?
Yes, yes, we followed this for the one.
All right, Caroline, could you pull that notice for me, please? All right, and it's the court's understanding that then the defendant is charged with aggravated assault with a deadly weapon, serious bodily injury, family dating. Is that correct?
That is correct.
Right. And the range of punishment for that offense is 5 to 99 years or life. And then with the repeater, the minimum is 15. Is that correct?
That's correct, Your Honor.
All right. Are both parties ready to proceed with jury selection?
State's ready, Your Honor.
The president's ready, Judge.
All right. And how much time are each of you requesting?
State's requesting an hour and a half, hoping to give the court that time.
All right. And defense, how much time you're requesting?
No more than 45 minutes. Judge.
All right. I'll give each side an hour and 30 minutes, and I'll give you all time announcements at 5 minutes. Is there anything else before the jury is brought in?
Nothing to say.
That's the defense.
All right, everyone, let's bring the jurors in.
Number one. The first row. On the bottom? Yes, in the bottom is this one. Okay. First row, right?
Yes, no. No, ma'am, we're doing what Michael wants.
Okay.
Number 8. Number 8, second row on top. Have a seat, you can have a seat.
That's all for Jane.
Up there, sir. Up there. 15 was good. Then you start the bench, ma'am. Um, 22. Ooh. 37.
Yes.
Everyone, please be seated. Excuse me, could you call this report or you must let her know your interest. So I can't answer the call. Sure. Thank you. All right, everyone, good afternoon. Good afternoon, everyone. Good afternoon. I mean, that was a slow response. All right, I'm going to check to see if everybody's awake. Good afternoon, everyone.
Good afternoon.
Awesome. So I know when you all came in, at first it was thought that we would not start with jurors sitting in the box, but defense attorneys and prosecutors sometimes like jurors to be placed in a specific way. So both the defense and the state don't have any issue with jurors being placed in the box over here, because sometimes it's a little bit hard for them to see everybody, because as you can tell, they're facing this way and you all are on this side. So I always like to give them the option sometimes, if we can, of changing the way the jurors are placed so it makes it much easier for them. I'm Judge Boyd. You're in the 187 District Court. We're on the 4th floor. Judge Boyd, 4th floor, 187 District Court. So where are we? All right, see, you know what? Everybody else started to drown out towards the end. It's like when you're singing a song and you know the first words and then everybody just starts mumbling like they do with Old Lang Syne. So the reason why I ask that, why I tell everybody that, is because when we're in the middle of jury selection, everybody has to be together when we're doing jury selection. And sometimes we'll take breaks and sometimes people get lost. We've had incidences where we're waiting for someone and that person is down the hallway, because there are many courtrooms on this floor and they're down the hallway trying to enter into their jury selection. So I do that to let you know that if you ever get lost, because sometimes people will say, I was sitting on the bench going through my text messages and I looked up and everybody was gone. So if that ever happens to you, all you need to remember is 187 fourth floor, Judge Boyd. Or if you just remember Judge Boyd, I'm the only Boyd in the courthouse. So this is a case that you've been brought for to serve on a jury, potentially, is the state of Texas versus Aaron Trevino. And I'm going to have the parties introduce themselves to you. State.
Good afternoon, y'all. My name is Michael Bexar. Good afternoon. I'm Renee, also with the state.
And defense.
Hello, everyone. Alfonso Cabañas, and this is Mr. Aaron Trevino.
All right, Mr. Trevino, you want to introduce yourself?
My name is Aaron Trevino. I got to come in. Taking time. Today.
All right, thank you. And everyone, just 1 second. Deputy Laura, there's someone who was supposed to be in court this day, but they're in the vestibule. Can you tell them to go around to the back? All right, thank you. All right, other persons who just introduced themselves, is there anyone who knows any of those parties? All right, could you raise your card? All right, you're number 7. And let me talk to you about those cards. So everyone should have a card. Maybe you're sitting on it. You didn't realize how expensive that card was and how valuable it was. So does everyone have their cards? If you can raise your card for me. All right, thank you. The reason why you have those cards is because nobody here can memorize everybody's name. So when you are responding to a question, or if there's something you want to say, just raise your card and everybody will acknowledge you, and they will have your question answered, or either you can ask whatever question. So juror number 7, who do you know? Okay. All right, thank you. All right, other than you all just meeting and getting to know each other and enjoy each other company in the hallway and meeting each other maybe downstairs in the central jury room, is there anyone here who knows each other than just meeting for those periods of time? Okay, that is so odd. Usually there is a teacher on here who has a student. One time we had a wife and ex-wife, so we don't have any of that happening. Oh, they got along just fine. It was fine. All right, so one of the most important people in this courtroom today is the person to my left. That's the court reporter. Diana, could you raise your hand for everybody? Thank you. So that is the court reporter. And in courtrooms, if she can't hear you, that means she can't take it down. And if she can't take it down, that means it didn't happen. So we want to make sure that everything we're saying happened. And the way to make that happen is for everyone to speak up loud enough so that she can hear. Everyone who's in the box, if you're answering a question, you don't have to stand because she'll be able to hear you if you keep your voice up. Everyone on this front row, starting with the person in the green jersey, could everybody on this row raise your card? Could everybody in the box raise your card? No, keep them up. Everyone, the people who have those cards raised, they don't have to stand when they're answering because everybody can hear them. You can lower your cards. Everybody else, if your card was not raised and you're able to, you're going to need to stand when you answer a question. So far, we've had no jury that's been able to remember to do that. So I'm hoping this is going to be the first panel who does it. I will be very proud of you. All right, so this court, it's on the criminal side of the building. The next building over with the green rooftop, they handle civil cases. So this courtroom handles adult criminal cases. So in this case, the charge pending against Mr. Trevino is aggravated assault with a deadly weapon, serious bodily injury, family or dating. So that's the charge. So I just want you to think about that for a minute, and then I'm going to talk to you about some more things. Now, when the state and myself or either the defense are asking you questions, these are all hypotheticals. Nobody is allowed to tell you anything about this specific case. So when people talk to you, it's a hypothetical. Does everyone understand? So nobody should be saying, oh, did this person do that? Or, oh, that's what happened in this case. No, you will not get any proposed facts about this case unless you're on the jury. Does everyone understand?
Yes.
Now, I want to talk to you about an indictment. An indictment is a document that's used to bring somebody to trial. And this is the best way I can explain it to you. How many people, and do not be shy, how many people have had a traffic ticket? All right, remember, raise your cards. These are all test questions, okay. All right, some people are raising their card, then putting it down quickly. That's okay, I still see you. All right, so I've had a traffic ticket before. So when you get a traffic ticket, and I'm going to age myself, when I got a traffic ticket, it was back in the day where they gave you a piece of paper and they have this whole big pad that's just filled with paper and they tear it out and they get to keep a copy. Now, my understanding is they do it all electronically or something. So let's say you get stopped for failing to follow the yield sign, which nobody in San Antonio knows what a yield sign is, or running a red light or not stopping at a stop sign. So when the officer pulls you over for that and gives you a ticket, you're accepting that ticket is not saying I'm guilty of it. That ticket is just to tell you, I'm saying you ran a stop sign, or this is what I'm saying you did. And this is where you need to be to address that issue. So when you get that traffic ticket, you can go over to Frio or wherever it may be, the municipal court, and you can have a jury trial. And the fact that you have that ticket is not an evidence of guilt. Does everyone understand? So indictments are the same way. Indictments are not an evidence of guilt. An indictment is just a document to let someone know who's accused. This is what we're accusing you of. This is the court where you need to appear, because everybody needs to know what they're being accused of. Does everybody understand?
Yes.
So an indictment is not an evidence of anything. Does everyone understand?
Yes.
Is there anyone who has a problem with that or can't follow that? Okay. All right. So, of course, there are certain rules in criminal cases, constitutional rights that people have. One of them is the right to remain silent. Has everybody heard of that?
Yes.
Is there anyone who hasn't heard of that? All right, so I assume everybody's watched Beretta, Barnaby Jones, Mannix, Paper Chase. I'm aging myself. Some of the young people are saying, I don't know what she's talking about. The Practice. So that's as far as I can go. So everyone has a right to remain silent. They don't have to testify against themselves on the criminal side. Nobody can call them as a witness. Now, there are many reasons why people may not want to testify. Maybe they don't speak the language very well, or they don't think they speak it very well. Maybe they stutter. There are a whole host of reasons why someone may decide not to testify. In the United States, if someone decides not to testify, you can be like Miss Kravitz from Bewitched and say, man, I would really love to know what they were going to say. But you cannot consider it if you're deliberating. Does everyone understand? So you can't hold it against them. It's best not to even talk about the fact that someone chose not to testify. Is there anyone here who would hold it against Mr. Trevino if he decided not to testify? Okay. The next thing I want to talk to you about is presumption of innocence. In the United States, everybody is presumed to be innocent. So as Mr. Trevino sits here today, you have not received any evidence. So if you had to vote on guilty or not guilty, what would it be? Yes, not guilty, because you haven't heard anything. Is there anyone who can't abide by that rule? All right. So now when I speak to you about everyone is presumed to be innocent, they're presumed to be innocent unless and until evidence has been presented beyond a reasonable doubt that they are guilty of what they've been accused of. Now, I can read your mind. You want to know, what is the definition of proof beyond a reasonable doubt? When I was in law school and graduated, everybody had to know that definition. And you felt like such a failure if you didn't know that definition. My first jury trial, I knew it. I was so proud of myself because I could recite it. Next jury trial I had as a defense attorney, guess what? No more definition. So there is no definition for proof beyond a reasonable doubt. And when I was a prosecutor and a defense attorney, what I would do then is I started telling people what it wasn't. So Proof beyond a reasonable doubt is the highest burden we have in this country. There's no other higher burden. So that building that I was telling you about next door, the one with the green rooftop that hears civil cases, their burden over there is, one of them is preponderance of the evidence. That's usually used when it's dealing with money or there's a car accident, more likely than not that person did what they're saying they did. That's not the burden over here. Proof beyond a reasonable doubt is higher than that. There's also another burden on the other side, and that burden is what's called clear and convincing evidence. Clear and convincing evidence is the burden that's used to make a determination on whether or not your parental rights should be terminated, which means that your rights to be a parent to your child is being taken away. That you might think that's a very high burden, but proof beyond a reasonable doubt is even higher than that burden. Does everyone understand?
Yes.
Okay. Now, there are two phases to every trial in Texas. First phase, people call that the innocence phase, but really it's the not guilty phase. Either you're finding somebody guilty or either you're finding them not guilty. That's the first phase. So in the first phase of a trial, if you find someone guilty, you go to what's called the punishment phase. If you find someone not guilty, there's no punishment phase because you determine that they're not guilty. Does everybody understand?
Yes.
Now, according to the law, anybody who is going to a jury trial on the criminal side must make an election or make a decision about, if I were to be found guilty, who would I want to do my punishment? And there's a choice. You can either say, I want the court, which would be me, the judge, to do punishment if I'm found guilty, or either I want the jury to do my punishment if they were to found me guilty. Does everyone understand?
Yes.
Now, when someone makes that decision of who they want to go to for punishment, that is no evidence of guilt on their part. It's just that the law says you have to make a decision in case you were found guilty. Does everyone understand? Is there anyone who's going to hold it against Mr. Trevino? Because Mr. Trevino has elected or decided that if he were found guilty, he would go to the jury for punishment. Is there anyone who would hold that against him? All right. Now, I want to talk to you about the range of punishment in this case. In Texas, all levels of felonies have wide ranges of punishment. So in this case, the range of punishment may be anywhere from 5 to 99 years or life in prison, or 15 to 99 years or life in prison. And that's a wide range of punishment. And you don't know, one, in a situation, what you would consider giving someone for punishment until you've heard some facts. Would everybody agree with me on that?
Yes.
So a lot of times people will ask you, well, would you give this? Would you give 5 years? Would you give 6 years? Would you give 7 years? What would you give? And it's pretty hard to say, I would think, when you haven't heard anything. So the law is, that's the range of punishment. Does everybody understand? And so the question is, would you be able to consider the range of punishment? Not give it, but would you be willing to recognize that in some cases, the minimum amount of punishment is 5 years, the maximum amount is life or 99 years. And then in some cases, the minimum would be 15 years prison and the max would be life or 99. Does everybody understand?
Yes.
Would everybody be able to consider that?
Yes.
Is there anyone who would not be able to consider that? All right. The next thing, and I always wonder how to answer, how to do this question. And I just do it. And each time I ask this question, I always say there's a new way that I should come up with it. Is there anyone here where English is not your first language? All right, number 40. Anyone else? 64. Anyone 61? Anyone else? Okay. And see, my problem is when I ask that question, because we've had some people who do not speak English and they don't understand what I'm saying when I ask that question. But I think all languages are beautiful. I'm originally from Louisiana, so it never occurred to me to take Spanish in school. So if you want to speak French, I will speak French, but Spanish, I am working on it. It's a work in progress. So juror number 40. Have you been able to understand what's been happening?
Yes, I did, but I'm anxious that I won't understand that.
I'm sorry?
I did understand, but I'm anxious, like I want, especially if this is criminal case. I'm anxious that I want to understand, or if somebody speaks like a low voice, I cannot understand.
Oh, we're going to make sure everybody speaks up. Thank you so much. 61. Yes. How long have you been in the United States? Okay, so remember, keep your voice up so the court reporter can hear. All right, so have you been able to understand everything? All right, and what's your native language?
It's Hindi.
Hindi? Okay, that's something new. We haven't had that. How do you say hurry up in Hindi?
Jaldi karo.
All right, I know you won't be able to write that down. Thank you so much. I always ask that question because in law school, some of my best friends are from all over, and some of them speak 3 and 4 languages, and they would try to teach me. And the only thing I could really learn from them is how to say hurry up. So I probably know hurry up in every language. And one of my friends, her parents said, that's all you taught my second daughter. No. So I'm working on it. Number 64. Hello, what's your language?
That's Spanish.
All right. How long have you been in the US? I'm sorry? 12 years. All right. Have you been able to understand everything?
Yes.
And how do you say hurry up in Spanish?
Apúrate.
Oh, are you able to get that down? Yeah. All right. Thank you. All right. The other question I want to ask you all is there anyone here who, for religious reasons or whatever reason, feels as though they can't sit in judgment of anyone? All right. Now, the next thing I want to talk to you about is travel arrangements. Is there anyone here who has travel plans that are coming up, non-refundable tickets? You can't put it in my name. Is there anyone? See. So number 30, 39, and 70. All right. And then also, is there anyone else who has time constraints? Because sometimes we have people who say they have a doctor's appointment coming up. Is there anyone who falls under that? Number 8. All right, here we go. 19, 1. Well, let me do this. 1, 8, 19. And once I call your number, you can put it down. 24, 25, 29, 33, 50, 54, 69, 70, 71, and 74. All right, juror number 1, what's your issue?
I have patients scheduled starting tomorrow, so
All right, and I know there are HIPAA issues, but patients for what specifically?
IV therapy.
IV therapy? All right. And what does that consist of?
Fluids, medication, vitamins.
All right, thank you. Number 8.
I have an orthopedic appointment tomorrow that's been scheduled for like 5-ish months and possibility of a surgery next week.
Okay, and you say been scheduled for 5-ish months?
Yeah,
Okay,
it's been a while.
all right. And that's scheduled for tomorrow?
Yes.
All right. All right, and then number 19.
Yes, I have to pick up my daughter by 3 o'clock today. And I'm the only one who picks her up from school.
Okay,
And yeah, I live across town, so I don't know if that's gonna be.
okay. All right, number 24.
I have a doctor's appointment on Tuesday, the 21st. And then I also have another doctor's appointment on the 23rd.
All right, so everyone remember to make sure your voice, as I always tell people, speak to the back of the crowd. And the court reporter is the crowd. All right, thank you. Number 25.
I have a dental appointment tomorrow.
What time? All right, thank you. 29,
I have a doctor's appointment, but I don't know if it's next week. I don't know when. I can check my phone, but I'm an asthmatic, so I've been having issues with allergies and stuff.
all right, you may want to check that. I mean, you don't want to not show up for that. But then blame me and say, well, that judge wouldn't let me go to my doctor's appointment.
You want me to, check it right now?
Oh, you can check it as I
Oh.
go through the rest.
Okay.
So if you want to pull out your phone and check that, and I'll rotate back to you. Number 30. Hi,
I'm flying to Indiana tomorrow morning. Back on Friday.
what are you doing in Indiana?
That's my company. It's our rescheduled Christmas party that it's over in Indiana. So I have to fly from Chicago and things shut down in December. So we're doing our gift exchange in the morning, our Christmas party at night.
So is there anybody on this jury who feels sympathy for her?
Yes, she had a Christmas like that. I had to go get something different now because Christmas has passed.
All right, thank you. Number 33.
We only have transportation for my children and they get off to school about 3:00 as well.
All right, thank you. Number 39.
I have an airline ticket on Friday
Where are you going?
to Tucson
What are you doing in Tucson?
with my son.
What does he do there?
This
Does your son want you visiting him in Tucson, or does he want to hang out with his friends? It happens.
Mom's, yeah.
Usually children just want you to pay the bill. But okay. All right. And what time are you leaving on Friday?
Like a 7 a.m.
Ah, okay. All right. So you have to be there probably at 5. All right. I hope he appreciates that. Thank you. Number 50.
A doctor's appointment at 9.
Okay, thank you. 54.
I have a doctor's appointment tomorrow too.
Okay. 69.
I have a doctor's appointment tomorrow at 1:45.
All right, you guys could carpool or something. Number 70.
Yes, I have a vacation that starts tomorrow afternoon for my in-laws' 50th wedding anniversary. And then I have a scheduled surgery
And when is your surgery?
on the 1st of March.
I could be wrong, but I don't think we're going to be here March 1st. Now, the other thing is, do you really want to, the vacation with your in-laws, is that here in San Antonio?
No,
Where is it?
and Waxahachie.
Oh, okay. I've driven through Waxahachie. So do you want to be there? Really? Okay. All right. Thank you. 71.
I have a funeral viewing and service for my grandfather Thursday and Friday.
All right. I'm sorry to hear that. 74.
Well, I had a doctor's appointment today, which I rescheduled. It's rescheduled for next week on Monday, and then on Thursday I fly out to Santa Fe.
Okay. What are you doing in Santa Fe?
Go skiing, Monica.
Oh, I would love to. Thank you. I can't ski, but I'll watch. All right. Thank you so much. All right. So everyone, remember to keep your voices up. And if anybody ever needs a break, just do that sign and we'll recognize you and we'll be able to take a break. I'm going to give you right now a 10-minute break because I need to get a couple of documents. That's what a text message is about for me. It's a emergency type of docket, but it's nothing related to this case at all. And you may see in this court, sometimes people are coming through that door. They're coming through that door because they don't read the sign that says, do not enter jury trial in progress. The people who are coming through this door are usually staff who are having me sign different documents. So just ignore when people come through that door because it's nothing to do with this case. And you may see sometimes people come through that way and then they'll look in and see that we're doing jury selection and step back out. So I'm going to give you all about a 10-minute break. We're going to be back here at 2:40. So look to your left, just one second. Look to your left, look to your right. That's the person that you are responsible for and making sure they get in line. All right, everyone, please rise for the jurors. And Deputy Laura, can you mute us? All right, everyone, please be seated. All right, so the juror number 29. So do you know when your appointment is?
Yes. Wait. No, the numbers. Not the 29th, it's the 27th.
No, your card is 29.
Yeah,
So-
I was getting mixed up. It's the 27th.
Oh, your appointment is the 27th?
Yes.
All right, don't miss that appointment.
Okay.
All right, so if anyone at any time is having a problem hearing what's being said, do not be shy, raise your card and let us know. Am I understanding juror number 73? Have you been able to hear everything?
No, I'm good. I just missed a little bit of it here and there.
All right, anytime you're missing something or you can't hear, because both parties want to make sure that everyone hears what they're saying, just raise your card. No one will hold it against you. Everybody wants everyone to be able to hear what's going on, okay? Now is not the time to be shy. So I'm going to tell you all two stories. Both of the stories are very true. So my uncle grew up in this small place called Grand Cane, Louisiana. Probably now it's probably like population, maybe, I don't know, 850 or something like that. When he lived there, the population was like maybe 1,200. He's since passed. But when he was in school, super intelligent. So the teachers would always pass him to the next grade. So once he graduated from high school, the Vietnam War broke out and people were being drafted. And so he went to my grandmother and said, I just want to go ahead and join because they're drafting everybody here anyway. So my grandmother had to sign for him to go. And as you can imagine, I'm sure the parents, that's a very difficult thing to sign for your son to go off to war, and especially when they're underage. But she signed for him to go off. And the reason why I bring that up is because our government doesn't ask a lot of us. You know, somebody tell me, well, we have to pay taxes. I'm like, okay, they ask for you to pay taxes. You don't have to vote. You don't have to register to vote, which, you know, I won't say anything about that. But they don't even, the government doesn't even ask for you to vote. The only thing they ask of you is to pay your taxes and to serve on jury duty. And I always tell people, I know that there are other things that you could possibly be doing today that you probably want to be doing, but we cannot have jury trials if we do not have jurors. And when you look at it in the big scheme of things, this is a small part of your entire lifespan on the planet. So unless the rules change and the law change where they're drafting people, the only thing the government is asking of you, two things: pay your taxes and show up for jury duty once in a blue moon. All right. The other thing I want to tell you about is one of my friends I went to with law school. We're still great friends. We're like sisters. So she decided to do civil law. I always wanted to do criminal law. I always knew that's what I wanted to do from the time I was watching Perry Mason. I'm like, this is what I want to do. So we didn't get a chance to see a lot of each other after law school, because usually on the civil side, you're constantly in the office. But on the criminal side, you're always in court almost every day and in trial at least once or twice a month. So she called me and said, I have jury duty. Let's do lunch. I'm like, great. So we sit down, like time has not passed. I asked her, how is jury selection going? Because they were on a break, lunch break. She's like, it is going fabulous. And I'm like, I've never heard that before, even though maybe I hadn't heard it because people were not in the 187 district court with Judge Boyd. But she said it was going fabulous. And I said, why do you say that? She's like, oh, I'm not going to be selected. I said, what do you mean you're not going to be selected? She's like, it's like law school. I'm on the back row, keeping my head down, not answering any questions. And so I started laughing at her hysterically. And she's like, what's so funny? I said, we are going to end up having lunch all week. And she's like, why is that? I said, because you are so getting selected. She's like, why do you say that? I said, for some reason, prosecutors and defense attorneys, when they're looking at their lists, they're always like, oh, this person never said anything. Let's put them on the jury. So other than raising your card and saying, please pick me, the other way to be on the jury panel is to be quiet. So with that being said, and I do that to start the conversation going because both sides really want you to talk and get to know you. And this will be the only time that they get to talk to you and you get to voice your opinions to them. So with that being said, I'm going to turn it over to the state.
Thank you, Aaron. All right. Good afternoon, everyone. So I try to give you that warm up so you know what to expect, right? So yeah, my name is Michael Villarreal, and along with my partner Ruben Hedetta, we represent the state. So we're gonna spend some time with you this afternoon talking about the law, what your thoughts are on the law, what you believe is on the law. So who, when they got their jury card in the mail, thought this? Especially knowing that it's Valentine's Day, right? What a romantic place to be at the courthouse. I use this, okay, from both the defense and the state, we appreciate you being here. Without jurors, we can't try cases. So this is an important part of the process. So I use this picture to help illustrate what is the purpose of VOIR, or as some people north of the Mason-Dixon line might say, voir dire. So who knows who this is? See a lot of cards. Juror number 18, who is depicted in this picture? Willie Nelson, right? And what does Willie Nelson love? Hint, it's in the picture. Marijuana, right? So is Willie Nelson going to be necessarily a good juror for both the state and the defense on a possession of marijuana case? No, right? He understands the law as it relates to possession of marijuana. He just doesn't agree with it, and he clearly does not follow it. So what we are trying to figure out is whether you understand the law, as we're going to explain to you, and then whether you can follow that law. Okay? So I'm going to call this the Willie rule throughout my presentation. So all we're expecting you to be is honest. I like to say this is the one time you can state your opinion to a lawyer and a judge, and we're not going to argue back. Don't try this with your spouses, especially today. So that's the Willie rule. Does everybody understand the Willie rule? Everybody agree to abide by the Willie rule? Okay. So for those who are not maybe as like visual people are a little bit more like my brother who think like on the math side of the brain. Think of this as an equation. What we're looking for is a fair and impartial jury, which is made of jurors. So what is a fair and impartial juror? You're going to follow the law that the judge is going to give to you, and then you're going to base your decision only on the facts that are presented in the courtroom. Okay? So that's how you get a fair and impartial juror. Does that make sense to everybody? Yes. Does that not make sense to anybody? Okay. So just talked about this briefly, but beyond a reasonable doubt. Like she told you, we cannot define for you what beyond a reasonable doubt is, but we can tell you what beyond a reasonable doubt is not. It is not beyond all doubt, not 100%. Possible doesn't mean that it's reasonable necessarily, right? Is it possible? I don't know. Some sci-fi version of something happens, right? Aliens are involved, or I don't know, Terminator or something, I guess. Does that mean that it's reasonable? submit to you that in most of those cases, probably not. And then the reasonable doubt only applies to the elements of the offense. And we'll go through the elements of the offense in a minute. But this is to say, if we prove to you every element beyond a reasonable doubt, but you have a reasonable doubt whether the victim or defendant or witness was wearing a red shirt versus a blue shirt, so long as that's not an element of the offense, and you think that we've met every element of the offense beyond a reasonable doubt, that's a guilty verdict. Does that make sense to everybody? Okay. So I like to use this picture to illustrate what beyond a reasonable doubt might mean. And I'm using very simplified versions of all these. Not that we don't take these cases seriously, but this is, I'm assuming a lot of y'all come to this courtroom without these types of experiences within the criminal justice system. And so trying to use everyday things to help explain some of these concepts to you. So with that being said, who here has dog or dogs as show cards? I see a lot of hands. Okay. Who here, those who raise their card, have come home to a situation like this? I show cards. Okay. I feel like there's a lot of overlap there. Okay. If you use those cards up again one more time. And of those who raise their cards, who here just has one dog? 14. We can use you for a second. Tell me what happened.
I came home, there was a bunch of people that
Ooh. I haven't been in school in a while, but I remember textbooks are not cheap. Were you there to see it happen?
No.
But you know beyond a reasonable doubt that it happened, right? This is to help explain to you that you don't have to be there to see something happen to know that it happened beyond a reasonable doubt, right? You can use the facts and circumstances surrounding it to get to that conclusion. So, right, you only have one dog. There's no evidence of a book terrorist coming in there and ripping up your textbook, right? The doors are locked when you got home, right? All of those things you can use to make reasonable conclusions about what happened. Okay, because if you were there and you saw it happen, would you necessarily be a juror on a case? No, right? You would be a witness, so you'd be on a different part of this trial. Okay, does that make sense, everybody? Okay. So, as promised, here are the elements that the state has to prove to you beyond a reasonable doubt. That on or about date in Bexar County, Texas, the defendant intentionally or knowingly or recklessly caused serious bodily injury to Regina Briones. Anybody know anybody by the name of Regina Briones? Okay. Who sometimes you'll hear is referred to as victim or complainant, one of those things. By doing something, we call this the manner and means, so how they did it. And during the assault, they used or exhibited a deadly weapon, and that Regina Briones was in a dating relationship with the defendant. So those are all the elements that the state has to prove to you beyond a reasonable doubt. A lot of these are not, I anticipate, won't be necessarily super contested, and so I'm not going to spend a lot of time on things like Bexar County or dates or things like that. So first thing I want to talk to you about is, we call this like the mental state, the intentionally or knowingly or recklessly. So these are the definitions that our code gives us as it relates to these three different mental states. So intentionally, your conscious objective or desire to engage in the conduct or cause the results. Knowingly is you're aware that conduct is reasonably certain to cause the results. And then reckless is you are aware but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. So I think intentionally or knowing, like you're, even though they use a bunch of words to say those, I think those are pretty much as kind of self-explanatory. Did you intend to do it? Did you know that that was going to be the result? Did you know that you were doing this? Right? Reckless is like, this is kind of like the mama law. You ought to know better. Right? You knew that there was an unjustifiable risk, but you did it anyways, right? You didn't maybe necessarily intend, but you didn't know, but it was reckless because you knew that this result could happen. So it's like, I've been talking to you and I grab something the jury panel, I grab something heavy and then I throw it behind. Right? I know that you're all sitting there. I know that it's likely that it will hit somebody. Do I know that it will? No, but it's an unjustifiable risk. Because I know that you're sitting there. I know that if I throw something behind me, it might hurt you, right? That's a way of thinking about reckless. Does that make sense to everybody? Okay. So you'll notice that when I put in there intentionally or knowingly or recklessly. So with that, we just have to prove to you one of those. And you don't have to be unanimous if you were on the jury as to which one it is, so long as you believe beyond a reasonable doubt that it's either intentionally or knowingly or recklessly. So what I mean by that is there's 12. Let's say 4 of you say, I believe that it was intentionally beyond a reasonable doubt, right? The next 4 say, I believe that was knowingly beyond a reasonable doubt. And the next 4 say, I believe that's recklessly beyond a reasonable doubt, right? You believe at least one of them has been met beyond a reasonable doubt, then that's a unanimous verdict. You all 12 don't have to say, oh, it's all intentional. All 12 of you don't have to say, oh, that's all recklessly. So as long as you agree that it's one of those 3. Does that make sense to everybody? Yes. Does anybody have any questions on that? And I'm going to move on past this. So serious bodily injury. This is actually defined within our code. It is bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss of or impairment of the function of any bodily member or organ. So those are 3 different ways that the state can prove to you beyond a reasonable doubt that it is serious bodily injury. So looking at those definitions, what types of injuries do you think might constitute serious bodily injury? Any cards up? Number 1.
Broken arm.
Broken arm, maybe, right? Juror number 54, if you could stand for me. Paralysis. Anybody else? Juror number 56, if you could stand for me.
Stabbing.
Stabbing, right? Maybe. Juror number 6.
Choking.
Choking, potentially, right? Juror number 75.
Gunshot wound.
Right? Maybe gunshot wound. Juror number 60.
Burns.
Burns, right? Juror number 66.
Broken bones.
Broken bone. Right, those are all things that can be, right? So we're looking at whether that bodily injury just means pain, creates a substantial risk of death. So is it likely that it might cause death? Serious permanent disfigurement. So did it disfigure or change the way somebody looks or is permanently? Or protracted loss or impairment of the function of any bodily injury. So think about things like, if you broke something and it doesn't feel correctly, so you can't use your arm right or your leg right. So that might be that protracted use. You can't use it the same way that you did before. Okay. Does that make sense to everybody? Does anybody have any questions about serious bodily injury? So next one I talked about is that we have to show that the defendant used or exhibited a deadly weapon during the commission of the offense. So our code defines this in 3 different ways. First is a firearm. Our code just says, by a matter of law, a firearm is a deadly weapon. That's an easy one. Second definition is anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury. So that means, was it made or designed in a way that it intended to cause death or serious bodily injury? I mean, thinking about a gun, was that designed in a way that is for the purpose of inflicting death or serious bodily injury, right? You shoot somebody with a gun. So that's one way it's defined. And the last way that it's defined is that anything that in the manner of its use or intended use is capable of causing serious bodily injury or death. So these are things that might not necessarily be designed or intended to cause serious bodily injury or death, but the way that it was used did cause serious bodily injury or death. Does that make sense?
Yes.
So thinking about those three definitions, nobody answer firearm for me, please. What things might constitute a deadly weapon? Juror number 20. A bat, maybe, right? Juror number 18. A knife. A knife. Juror number 17. The weights, heavy weights. Juror number 52, if you could stand for me,
Beer bottle, broken beer bottle.
right? Little bar fight. Juror number 14. A car, right? Juror number 27.
Crowbar.
Crowbar. Juror number 67. If you can stand for me. Power tools. Power tools, like saws, drills. Anybody else? So there, juror number 60,
Extension cord.
maybe, right? And if you cause, it was choke somebody with it, maybe, right? Juror number 12. Pipe bomb. Pipe bomb, right? Let's think a little creatively. I mean, these are some cases that I'm not trying to get anybody ideas. I'll be clear about that. Okay. Let's just think creatively here. There's actually some case law about like water. Can water be a deadly weapon? Right? It's definitely not designed to cause death or serious bodily injury, but the way it's used can, right? Does that make sense to everybody?
Yes.
Do those definitions make sense to everybody? Does anybody have any questions about deadly weapons? So, you saw on the slide that when I was talking about the elements, part of it, we have to show that these are the family violence case essentially. And so these are the ways that our code defines family violence and dating violence. Family violence includes any act by a member of a family or household against another member of the family or household. Family violence includes dating violence. And in dating violence, I think the most important part of that definition is on that third bullet, is that it is committed against a victim with whom the actor has currently or has had a dating relationship with. So this includes current boyfriend, girlfriend situations, but also includes ex-girlfriends and ex-boyfriends. Does that make sense to everybody?
Yes.
Is it a problem for anybody that our code allows for things like ex-boyfriends, ex-girlfriends to be included within this family violence definition? Very strong though, from juror number 28. Yes, thank you. Okay. So this is a quick way to get a snapshot, because unfortunately I'm not going to be able to spend a lot of time with all 75 of you as much as I want to. Get a quick snapshot about how you feel about certain things. So this is a weighted, a choice question. So you have to choose one of the four. You can say, well, maybe I'm a little 1, but I kind of lean towards 2. This is, you got to just choose one, which whenever best fits your answer, okay? So the question is, family violence is a private matter and the state should not get involved. Answer number 1 is strongly disagree. Answer number 2 is disagree. Answer number 3 is agree. And number 4 is strongly agree. Again, the question is, family violence is a private matter and the state should not get involved. 1, strongly disagree. 2, disagree. 3, agree. 4, strongly agree. So by a show of cards, who falls into category number 1, strongly disagree? Okay. Once I call your number, you can put your card down. 3, 8, 9, 11, 12, 13, 16, 17, 20, 21, 22, 23, 24, 25, 26, 34, 40, 41, 42, 46, 47, 48, 49, 50, 53, 54, 57, 59, 60, 66, 67, 68, 69 through 73, and 75. Okay, who falls into category number 2? Disagree. see, 1, 2, 4, 5, 6, 10, 14, 15, 18, 27, 28, 29, 30, 31, 32, 36, 38, 39, 43, 44, 45, 51, 52, 55, 56, 58, 61 through 64, and 74. Okay, who falls into category number 3? Agree. Nobody? Okay. And then who falls into category number 4? Strongly agree. Okay. So talking about family violence cases, why is it important to prosecute family violence cases? Juror number 63.
For the safety of other families.
Safety of other family members. Anybody else? Juror number 27.
The issue can go out of control very easily.
Right, so maybe escalation of violence is what I'm kind of hearing. The cycle of violence, maybe. Anybody else? Juror number 62.
Safety of the public, should go to your family.
Right. They kind of understand that to mean like it can get out of the household, right? It can affect other people. Juror number 26.
More people to come forward and be set as an example that something can be done about it.
Right? Good answer. Anybody else? Juror number 67.
It's not addressed, you get. Don't repeat it.
Right, kind of similar to what juror number 27 was saying, like it can happen over and over again, that cycle. Anybody else? They're all good answers, right? We have to think about like the relationships between these people. Are victims always necessarily going to come forward with charges or what they're saying is happening? Why not? I see your juror number 1 said fear. Anybody else? Juror number 52. You're scared. Juror number 18.
They're embarrassed.
Embarrassed. Juror number.
I was gonna say embarrassed as well.
Thank you. Juror number 49.
Because of the power dynamic.
Right, power dynamic. You don't have any like victim services background, do you? It's a very term of art, a lot of people. Juror number 58.
Maybe it's happened before and nothing came to it, so they don't want to do the next.
Right. Juror number 74.
I'm sorry, my fourth.
If you could stand for me, I'm sorry. Did you hear that? Juror number 60.
They might be scared of like what other family members think as well.
All right. Juror number 50.
I don't think it's their fault. It's not their crime.
Right, they put the blame on themselves. Juror number 56.
I might.
Like some internal conflict. Okay, all good answers. Do victims of family violence always leave their abusers? Yeah, a lot of no's, right? And just to kind of move this on, but those are for the same reasons we just kind of talked about, right? The power dynamics, right? The cycle of violence and things like that. Okay. So let's talk a little generally about witnesses in family violence cases. Where does family violence usually occur, or a lot of times occur? Juror number 15. In the home, right? Juror number 59.
Behind closed doors.
Behind closed doors. Anybody else? All right, I think that's kind of the understand answer. So in these types of cases, who's usually around? Juror number 53. Kids maybe, right? If there are kids, juror number 18.
No one.
No one. Juror number 17.
No.
Right, so sometimes these things don't happen out in the open, right? So let's think about it in this way. So actually, how many witnesses are actually able to testify in a lot of these cases? If you remember, like the judge taught you, the defendant has a Fifth Amendment right not to testify. That means he doesn't have to speak to police officers, and that can be not held against him. So knowing that, how many witnesses in these cases, or a lot of these cases, is the state able to call about what actually saw happen? Number 15.
Just those that were involved.
Right? Sometimes these are just victims and defendants, right? Sometimes there's more, but sometimes that's the case. Is that a problem for anybody? Here, number 15.
Yes, because I'm Christian, I follow Bible counsel, and it says about having at least 2 witnesses. Or corroborating evidence or something like that. Like he said, she said, would be very different.
Thank you for your honesty. Anybody feel the same way as juror number 15? See juror number 74. So I know I'm kind of beating a dead horse here, but so if we don't have any eyewitnesses, and how do you think the state proves family violence cases if there are no eyewitnesses? What witness do you usually use? Juror number 28.
Well, it could be that the person, just the evidence of the injury.
Think about witnesses though. What witness usually who was there is usually the state able have to prove these cases through. Juror number, if you could turn your car around. 55. The victim, right? So that's a lot of times that what we have to prove these cases through. So who here is, I'm gonna kind of change the question a little bit, but who here thinks that we shouldn't prosecute cases if we only have the word of the victim? Juror number 50. Anybody else? I've changed it a little bit. Who thinks we should not prosecute family violence cases if we only have the word victim? 50, 51, 1.
I think we should.
Okay, well, I'll take you off that list.
Yeah.
Big X. All right. So, in this hypothetical, you have to get robbed. I'm so sorry. You do not get a choice of not being robbed, because I've had some smart jurors try to outplay me on this one. So if you had to be robbed, which one of these places would you rather be robbed in? The empty alleyway on the left, or Memorial Stadium, which is on the right? I know for us Aggies, we'd be caught dead in Memorial Stadium, but let's put it any stadium. Who would rather be robbed in the picture on your left? Right. Juror number 12. It's because you have 2 daughters, right? Right, it's a perfect place to get robbed, but you don't want to get robbed in, right? I think it's understandable. We would like 100,000 witnesses, which I believe is what Memorial Stadium holds at this point, to be witnesses on the case, right? But is that really how these cases work? So, using this example, so I'll put you in the shoes. So after you leave jury duty today, you were so incredibly sad because you didn't make the jury. And so you're already kind of in a mood walking to your car. You're not really paying attention because you're such a bad mood that you didn't get to be on the jury and spend time with us for the next couple days. And you actually got here early enough that you got a parking spot in the garage. So you walk to the garage, and while you're in the garage, you get mugged. Somebody jumps you and they take your stuff, your purse, your wallet. Now this is Bexar County, so none of the cameras are going to work. You can't rely on that. Who thinks that's a case we should prosecute? You see them, you can identify them, no problems there. We should. That's the case we should. I know I've been doing shouldn't and shoulds too much, right? We should, right? Who thinks we should not prosecute that case? Okay. So it's another scaled question. Just to get a quick idea from you. So if only one person testifies, that is not enough to find someone guilty. 1 is strongly disagree, 2 is disagree, 3 is agree, and 4 is strongly agree. And the question is, if only one person testifies, that is not enough to find someone guilty. 1, strongly disagree, 2, disagree, 3, agree, 4, strongly agree. Okay. So who falls into category number 1? Strongly disagree. Okay. 3, 11, 13, 14, 20, 21, 23, 28.
Sorry, no.
No, take 28 off. 34, 35, 36, 49, 50, 54, and 56. Who falls into category number 2? Disagree. I see 4, 5, 6, 8, 10, 16 through 18, 22, 24 through 27, 29, 28, are you gonna add 28? 30, 31, 32, 37 through 45, 47, 52, 53, 55, 57, 59, 61 through 63, 60, 65 through 72. Actually, through 75. Okay. Who falls into category number 3? Agree. I have 1, 2, 9, 12, 15, 51, 58, and 64. And who falls into category number 4? Strongly agree. No strongly agree. So, as a juror, if you make this jury, you'll get an instruction at the end from the judge that you are to determine the credibility of the witnesses and the weight to be given their testimony. What that means is that you can believe, if somebody takes a stand, you can believe everything that they said. You can believe nothing of what they said, or you can believe some of the things that they said, but not some of the things they said, right? You get to determine the credibility of each witness that comes, takes an oath, and testifies for you, okay? So what types of things, kind of in our everyday life, do we look for when we're determining the credibility of somebody we're talking to? Whether that's our coworkers, our children, our spouses, things like that. What do you look for? Juror number 12.
Lies.
Lies, right? Juror number 9.
Body language.
Body language. Juror number 18.
Tone in their voice.
Tone. Juror number 26.
How many details in the story?
Like, seeing like consistency and details. Okay. Anybody else? Juror number 10.
Look in their eyes.
Look in their eyes. Anybody else? Juror number 49. You can stand for me.
Their past history, if they have any like history of lying.
Right? Anybody else? Okay. So these are the same things things I hear from juries. Demeanor. I think somebody talked about body language that might fall into that. Motive. I didn't hear anybody say this, but like, is there a reason they might be saying something a certain way, right? If they say it a certain way, maybe that benefits them or hurts another person, right? Do they have a motive to say what they're saying? Do they have a dog in the fight? what they say. I think juror number kind of touches on what juror number 11, I think was saying. Does it just make even sense? Is it clearly just a lie? Does it make any sense? Juror number 25, I think, or 26 talked about consistency in statements, and I'm going to talk about that just a little bit more. Right? Sometimes consistency might, in certain cases, add to the credibility, or if they're not consistent, diminish the credibility. So, I like to talk about this. I'm a San Antonio native, and we're talking about consistency in statements. So, who here has been to one of the Fiesta parades? Battle of Flowers, Fiesta Flambeau, see a lot of colors. Okay. So I'm a San Antonio native, and I had a tradition as a kid that my aunt and uncle every year they would take me to Fiesta, and they would take me to the Battle of Flowers parade. I specifically remember every time we would stop at Church's Chicken along the way. I know that's sad, that's the highlight of it. I liked food, I still like it. Before we went. And every year I enjoyed watching the parade. You get to watch all the duchesses and princesses, you can see their shoes, right? As third generation Aggie, nobody hold that against me. Love to see the A&M band when they would come. All the high school bands, all the cool floats. So let's take it in 3 different ways. So let's say right after the parade, I talk about the exciting floats that I saw. Do you think necessarily I'd be able to tell you the order in which I saw them, every single float, anything like that, right? Seeing a lot of no's, right? Probably not a very important part of my memory, right? Each individual one, nothing stands out. But I get the highlights, and I really enjoyed the Aggie band this year. I really liked this one float that had, I don't know, a cartoon character on it that I loved. I might remember those things. So let's say I tell that story to my parents when I got home. Do you think if I told my parents about that same parade 6 months later, I would have all the same details? No, right? Sometimes things stay, things might change a little bit. Does it mean that I didn't go to the parade? No, right? So that's one way of thinking about it. I also like to, for our sports fan, I don't think she's told you yet, but Judge is a huge LSU fan. So let's say it's in the context of a football game. So you have 3 different people watching the same game. You have a spectator, so like a fan, you have a ref, and you have a player. Do you think all 3 of them are going to get a consistent story about a certain play? No. Why or why not? Let's say why not? Juror number 51. It's different perspective, right? Juror number 28.
Well, the ref would be looking at, besides equally, the player and the spectator have their preference.
Right. So like they're looking for different things, right? Their objective. Judge is extremely fair. One of the most fair people I know. But if you have a football game and it's LSU versus, let's say, Florida Gators, she might have necessarily a different view of a certain play, right? Because she has maybe a little bit of a bias for it. If she does, it'd be very slight. But again, she's one of the fairest people. Right. So you have to think about what they're looking for, right? The ref's going to be looking at the place clean, right? If there's any fouls. A spectator is looking just to hopefully their team protected, or it's a good play. And a player is seeing it from their perspective, like on the field, right? They're going to have some detail that a spectator or even a ref might not be able to do. Does that make sense to everybody? So these are just things I want you to think about when you're thinking about consistency in statements, right? Inconsistency doesn't always mean that something is not true. Again, but it also doesn't mean that something is necessarily, if something's consistent, doesn't necessarily mean that it is true. Does that make sense? You have to think about all those things when you're looking at that. Okay. So, talking about evidence on these cases. testimony is evidence. Okay? Testimony is evidence. Now, whether you believe that evidence or don't believe that evidence, that's what you get to do as a juror, right? That is evidence. Everybody understand? So, what type or kind of evidence would you expect in these types of cases? Juror number 8.
Possibly like a photograph if there is visible injury.
Photograph of a visible injury. Juror number 9. I'm sorry. Weapon. A weapon. Juror number 13. Do you have a card? Okay. Juror number 4.
Medical records.
Medical records. Anybody else? Juror number 6. Clothing, maybe, right? Juror number 56.
Testimony of the victim.
Testimony of the victim. You took that. Right, another witness, right? Juror number 67.
I'm sorry. my God, thank you.
Sorry, I'm standing in between. That's my fault. Is it phone records? Phone records. Okay, maybe, right? Yeah, juror number 60.
Maybe like.
Maybe text messages. Juror number 12.
I gotta say this because there's videos everywhere. Anywhere it's at.
Right? Maybe. Not come to my house, but
On their phone, they're doing-
right, so that's a possibility. Yeah, juror number 70.
A police report.
Police reports. That's one thing that's kind of interesting. A lot of times police reports don't come in. That's kind of our law on those things, but you might have police officers come in and testify. Juror number 75.
DNA evidence.
Maybe DNA evidence. Yeah. Right, so it's gonna be all talk about like photos, videos, maybe other witnesses. Is there anybody who says, Michael, with the exception of maybe, I don't want to say with the exception, but anybody here says, well, I would have to have this particular piece of evidence shown to me, even if I believe the other evidence beyond a reasonable doubt that it happened. Like, Michael, you proved the case to me beyond a reasonable doubt, but you didn't give me any photos, so I can't find him guilty. Or, Michael, you proved the case beyond a reasonable doubt, but you didn't give me any videos, so I can't find him guilty. Anything like that. I don't see any cards. Last thing I want to talk about, kind of generally, topic of punishment. So, like the judge talked to you earlier, if the defendant is found guilty, that's only if the defendant is found guilty, then the jury is going to assess his punishment. So, generally speaking, for this offense, the first degree felony, it's a fine not to exceed $10,000. Confinement in prison for a term not less than 5 years, but no more than 99 years or life, are both such fine confinement. So you can give a fine, you don't have to give a fine, you have to make a determination of basically a prison sentence, or you can give both. So knowing that that is the range of punishment, anywhere from 5 years to 99 years or life. Is there anybody who says, I can't follow it knowing what the elements of the offense are? I could not even consider 5 years, or I could never consider 99 years or life at either extreme. Let's see any cards up. Okay. So there's another area of our law that is called the repeat offender law. So this may or may not apply in this case, but I just generally talk about these in VOIR. So, in order to show somebody is a repeat offender, you have to show that they've been to prison before they committed this offense. So they went to prison, or it's TJJD or TYC, that's the Texas Juvenile Justice Department or Texas Youth Commission. It used to be called the Texas Youth Commission. That's juvenile prison once before. So if the state proves that, then that range of punishment increases. And really what only thing increases is that bottom, the floor, which changes it from 5 to 15. Does anyone have a problem that the state can use, if it is applicable, a prior trip, the prior history in this case, to enhance the punishment?
I have a question.
Yes,
Does it have to be the same act?
does it have to be,
The same act as prior, what is the prior?
so this law just says that you've been to prison before, and that after you got out of prison or TYC/TJJD, then you committed this new offense, the one that they would be on trial for. Right? Basically, you've been to prison, you got out, and then you committed it as a crime. The crime being the first part of this trial, that guilt innocent portion. Does that make sense? Yeah. Number 63.
So for mild clarification, the jurors potentially wouldn't know what the TYC reasons were for that punishment,
So
to give a broader.
And-
scope.
and this again, this would be just in the punishment phase. If we got there, you would get most likely, you say how the state proves this is prior judgments and things like that. So we would actually have to prove when they went, for the offense that they went, and when they went, and for how long they went. Those are all things that we would have to prove that if this applies. That makes sense, everybody? Do we have any questions? Okay, kind of going back to the question, is there anybody who has a problem with the state being able to use these prior prison / juvenile prison trips for purposes of punishment enhancement? Turn number 49.
I would say like if it's not used in the right context, maybe like the prior offense, then that would be a problem.
Okay. Turn number 44. You can see it from-
Oh, I'm sorry, I can't hear. If you could make sure you speak up, please.
Based on the current crime.
Okay. Anybody else? Turn number 51. I'm sorry, 51. I'm gonna put my eyes are crossing there. Turn number 1.
I would have a problem too, as far as if it was totally different offenses and if they've already done the time for something and never did it again, and then it just happened to be another incident or something totally different, I would have that problem.
Turn number 39.
I agree with what they're saying, if it's a different part.
Who agrees? And let me phrase it this way before I get some more cards out. If this law applies, you get to make the determination of whether it's true or not true. And then if the state has proven it beyond a reasonable doubt, then the judge would instruct you that if the state has proven that beyond a reasonable doubt that prior, you were to assess punishment at 15 to 99 or life, right? So this is an issue of, I want to feel out kind of who just disagrees with it, and then who, knowing that law, says, I understand that law, Michael, but I won't follow it. Does that make sense? Kind of going back to the Willie rule. So by a show of cards, just disagrees. I'm not saying that you won't follow the law, but who disagrees with that law. Okay. I see there's numbers 1, 4, 6, 11, 13, 15 through 20, 22, 25, 27, 29, 30, 31, 32, 35, 37, 39, 45, 46, 47, 48, 50, 44, did I recall you? 44, 51, 52, 53, 58, 59, 60, 67, 69, 70, 73, 74. Okay. So this question is different than I'm going to ask you. This is, Michael, I understand the law. I disagree with the law. And if the judge instructs me that I have to follow that law, I won't follow that law. Does that make sense? Kind of the Willie rule. I understand it. I might disagree with it. And I won't follow it. Does anybody fall into that category? Does that make sense? You have
I
a little
guess it
puzzle
sounded
book.
the same to me.
All right, so let me just All right, so the rules are, and the law is that if it is determined that someone has been sent to prison before, that can be used to enhance the range of punishment. Does everyone understand that?
Yes.
So that's the law. So the question he's asking is whether or not in a hypothetical situation, if someone has been to prison before and that someone were to have found them guilty, and the law says the range of punishment, hypothetically, let's say the range of punishment is 2 to 20 years. But because maybe somebody's been to prison before, the range of punishment is now 5 to 99 years or life. So that means their range of punishment will no longer be like any other ordinary offense. If it's somebody's first time of 2 to 20, it'll be 5 to 99. And that's what the law says. Is there anyone who will not be able to follow the law? That's the question he's asking. All right, you may continue.
And again, just. I understand there's a lot of cards that are raised for I disagree with the law. This is just the Willie rule of I will not follow that law, even if the judge instructs me I am to follow that law. I don't see any cards. All right. Next thing I want to talk about is a quick another one of these scale questions. What is the purpose of a sentence, right? Of assessing punishment. Number one is punishment. The defendant needs to be punished for the consequences of his actions. Or 2, rehabilitation. I need to help the defendant from reoffending. Now, a lot of you, I know are going to be, I'm 1 and I have some 2 in there. I'm kind of a mixture of both, right? I personally do. But what I'm asking is, which one do you more identify with? Okay, you have to choose just one. I know. It's not like I'm going to come back and like, you told me rehab. This is just to get a quick idea of where you are, okay? And so, which one do you more identify with? Punishment or rehabilitation? Okay, who falls into number 1, punishment? Let's see, 3, 5, 6, 8, 9, 10, 12, 13, 15, 17, 21, 23, 24, 25, 29, 34, 35, 36, 39 through 43, 46, 47, 48, 51, 54, 55, 56, 57 is your card up? 57, 58, 59, 61 through 64, 66 through 75. And I'm just going to assume everybody else is 2. There's one or the other, so stay a little bit of time. I'm going to move on. These are just some final questions for you. Anyone know someone who either, I should say this way. Has anybody here ever been accused of a crime or similar crime of family violence, or know somebody is close to somebody? That's for you to determine whether you're close or not. Anyone accused of committing family violence? Let's see. 3, 2, 3, 6, 10, 11, 13, 17, 24, 30, 37, 44 through 47, 51, 52, 29, 57, 63, 66, 67, 75. Okay. And 20.
Question.
Yes.
When you say accused, is it like they've made a police report, they've gone to court, or you know someone who has committed?
It doesn't have to necessarily be a formal, right? Like, when
Okay, well then, yes.
say 20 and 29. Okay, we'll be getting questions first. I'll get right back to your comments. Anybody else who I didn't call on that initial. Can you turn your card around for me? 49, 50, 54, 72, 74. Number 29, your question.
Okay, my question is, if it's someone like in your family, and
It-
like how long ago? If you was,
Those questions, family, whether it's not, that kind of all fits into my question. If to be not family, could be family, just somebody you know has been accused of. Is that a yes for you?
yes,
Okay, 20 and 15. So of those that raise their cards, who out of those who raised their cards, that person that they know, was arrested for that family violence? Let's see, 10, 11, 13, 17, 30, 46, 47, 66, and 67. I'm narrowing it down even more. For those who just raised their cards that they were arrested, does anybody feel like that accused person wasn't treated fairly through the process? Through the criminal justice process? Not treated fairly? Nobody? Okay. Does anybody know anyone who is a victim of this crime or a similar crime? That could be themselves or anybody that they know of family violence. Let's see, 1 through 4, 6, 10, 11, 13, 15, 17, 18, 20, 22, 24, 29, 30, 34, 36, 37, 38, 40, 44 through 47, 49 through 52, 54, 57, 63, 66, 67, 72, and 75. Yeah, sure. It can be, so I'm just gonna mark you as a yes. 50. For those who raise their cards, does anybody feel that that person who is a victim wasn't treated fairly if they went through the criminal justice system? As a victim, we're not treated fairly. Okay, juror number 17 and juror number 34. So I'm gonna ask juror number 17 and 34. Having that experience, feeling that that person wasn't treated fairly through the process, would that affect your ability to be a fair and impartial juror on this case? I see no for 17 and juror number 34. No. Okay. Now I hesitate to ask this question because I always get a lot of cards. But out of those who raise their cards, who knows who's been accused, does anybody think they can't be a fair and impartial juror because of that knowledge of the accused? I'm sorry, of the victim. Of the victim. I'm not victim. I can't be fair and impartial because that person, whether it's me or somebody else that I know that's a victim of family violence. I see 3, 13, 16, 29, 37, 44, 50, 51, 52, 54, and 57. Okay. So Judge already covered this question, so I'm going to move on from that one. Is there anybody else here who says, Michael, we haven't talked about this issue, but I can't be a fair and impartial juror on this case because of a reason we haven't talked about, and I need to let you know, or I need to let the defense know. 16. So you need to tell me that you can't be a fair and impartial juror on this case, but it's a topic we haven't discussed yet, right? I need to let you know I can't be a fair and impartial juror on this case because of X, but we haven't talked about that. Does that make sense? Okay, I see 69 and 73. Juror number 69, you can see it for me. What's the reason you don't show up to be there? Are you
My
comfortable with
brother,
that?
yeah, I can, my brother-in-law was murdered
Okay,
and in 2018,
sorry.
just recently, the trials come to Trevino County. And they found the guy to be incompetent, stand trial. And me, I'm angry. I don't feel my husband and my mother-in-law got. And it's just or something.
I understand what you're talking about. So I appreciate your honesty. Thank you. And there's another juror numbers. I'll start with 57, then I'll go to you.
That's not what the vote is.
Okay. Thank you, guys. Juror number 73.
The hearing issue, just afraid I might miss something that's important.
Okay. Usually, this is not the best situation for jurors to hear, but once we're in trial, we have mic and things like that that usually help. It's just, unfortunately, I don't have my Beyonce set up right now. To speak into a mic. But usually, if it's an issue about hearing, we can address that. Okay. All right. So I just had a couple quick questions about that juror card that you filled out. We get all of yours. So, I have just a couple of questions. Juror number 10. You have previously served on a criminal jury?
Yes, sir.
Yes. What kind of case was it? Criminal? What kind of offense? Like family violence?
No French law, yeah.
Family violence? Okay. Somebody's giving me a hint. Did the judge or the jury decide punishment in that case?
The judge.
Judge did? Okay. Juror number 11, you were on a criminal jury as well?
It was that,
Okay, like a misdemeanor?
yeah,
Okay. You know how long ago it was?
like 3 years ago. I feel like I'm here every 3 years.
You get real lucky. I've had jury duty forever. Did the judge or the jury assess punishment?
The judge.
Judge, okay. Want to talk to juror number 34. You've been on a criminal jury as well? If you could stand for me. Okay. Was it here in Bear County? Okay, it was a criminal case?
It started as a criminal case thing.
Okay.
I hear him, I'm sorry.
They made it do that. So you don't even get to deliberate on that case. Okay, thank you. Juror number 41. You were on a criminal jury?
Yes,
When was that?
probably about 3 years ago.
Oh, not the same jury though.
No,
Okay. So y'all didn't raise your cards earlier. What kind of case was it?
drug
Okay. Did the judge or jury decide punishment?
judge.
Judge did? Okay. Thank you. Juror number 48. A lot of people on criminal juries. This usually doesn't happen. You're on a criminal jury before?
Yes.
And what kind of case was it? So the same type of similar offense? How long ago? Okay. And in that case, did the judge or jury decide punishment? The jury did? Okay. Were you able to reach a unanimous decision on punishment?
Yes, because we all wanted to go home.
Gotta get him starved out back there. Thank you for your honesty.
Yeah.
Juror number 56. You were on a criminal jury?
No.
Okay, I have it marked wrong. I'm sorry. Juror number 63. You were on a criminal jury before.
Yes, sir.
What kind of case?
It was a gang shooting in Sacramento, California.
Okay, it's in California. Do you remember if the judge or the jury decided punishment? Okay, so they're not guilty. Okay, thank you. Okay. Thank you. Juror number 7. Oh, it was a hung jury? Okay. Juror number 72. You were on a criminal jury before? Kind of some out of town jurors,
I know.
man. Importing them now. So on that case, the judge and jury decided. That should. Okay. I'm assuming that might be Louisiana law. Not Texas is unusual in the sense that A lot of states don't like juries decide punishment. Okay. Jury number 68.
When I filled out the form, it asked me for if I did a jury service court and it said civil, and I marked it. And then, but I've done civil and criminal, and I tried to mark both, but it wouldn't let me.
You know, there's a flaw in the system that we didn't know until now.
And or would be there, operator,
No.
I will concede that. However, I was in a, both of them.
Okay.
So I feel like, I should-
Thank you. As far as, was that here in Bear County?
yes, sir,
And
both of them.
as far as the criminal case is concerned, what kind of case was it?
It was a sexual assault of a child.
Okay. And how many years ago?
Long time. I think that was Ron and Carol, I think. Was president, that was work on it. It was 30 years ago.
He is still a judge. He's across the hall. So it's just the mirror version, maybe.
It's really, really long, it didn't look like this.
Okay. And so many years ago.
Oh, yeah,
Okay.
I can't recall.
And were you able to, did the judge of the jury decide?
It didn't, they was found not.
Not guilty, okay. Anybody else?
My person was found not guilty. I got confused with the last one. So,
Okay.
yeah.
Not guilty, okay. Anybody else? Okay. With that, I hope I'm giving the judge that time. We'll see. I thank you for all of your attention today and look forward to spending the next couple of days with the police. Thank you, guys.
All right, does anyone need a break or no? Okay. Don't be shy. If you need a break, it's fine. All right, so we're gonna, thank you. So we're gonna take a short break. If I have all of you back here by 4:10, is that enough time for everyone?
Yes, it is.
All right, so remember, look to your left, look to your right. All right, so everyone will have you outside and then we'll come back at 4:10. All right, everyone, please be seated. All right, defense, are you ready to proceed?
We're ready, Judge.
All right, you may proceed.
Thank you, Judge. Good afternoon, ladies and gentlemen. Before I go into my part of the presentation, I just need to ask you a couple of questions. So I'm gonna call out some names of potential witnesses that the state may call during their trial. And if you know them, just raise your hand so I could take note of it, okay? The first witness the state may call is an individual by the name of Regina Briones. Does anyone know Regina Briones? Okay. Another woman by the name of Kimberly Flores. Does anyone know Kimberly Flores? Okay. Then we have 4 law enforcement personnel, one by the name of Roman Rodriguez. No. Rachel Mendez. Jesse Moncada. Then we have 2 medical personnel. One is Rodney Chan. And then the last one is Jonathan Lundy. All right, ladies and gentlemen, so Mr. Villarreal talked to you guys about their burden, the elements of the offense, what this alleged offense is about, what they have to prove beyond the reasonable doubt. I'm going to switch gears. Okay, I'm going to focus a little bit more on your role as a potential juror. Okay, your role, the importance of it, what it means, what your job is. Because it is an important job. I know that the state put a meme up there, you know, kind of poking fun at being called for jury selection. I know it's not something that everybody looks forward to, but nonetheless, it is very, very important. Okay, it is something that everyone here in this room has under the Constitution, and primarily the reason we're here is because Aaron and everyone here, we're entitled to a fair and impartial jury. Okay, now, can anybody tell me why is it so important? Why do we need a fair and impartial jury? Anyone, I'm not gonna call anyone, just raise your number and let me know. Why do we need a fair and impartial jury? Number 41.
Anybody can be indicted.
Okay, because anybody can be indicted. Thank you for that. Number 66.
To avoid mistakenly sending an innocent person to prison.
Yes, avoid sending an innocent person to prison. Number 51. avoid biases in the court system, okay? It's not transparent, right? Okay, all right. No, those are very, almost like very to the T answers of what I was looking for. So for example, juror number 66, right? He talked about sending an innocent person to prison. I could not put it any better, okay? I cannot put it any better. Several years ago, I don't know if you guys remember or heard, there was a gentleman up in Williamson County who was accused of murdering his wife, okay? He went to trial. He was convicted, right? They found him guilty, went to prison. Years later, it came out that that gentleman by the name of Michael Morton was an innocent person. Okay, he didn't commit the offense. There was something else. And so years later, he was found innocent or, released from prison. But I bring that up based on what you said, number 66, because I can assure you guys that every single one of those people on that jury who got selected intended to do the right thing. They all took a note, they all heard and sat down like you guys did this afternoon, and they all intended to do the right thing. And so I want to focus on that because I want to let you guys know what your job is going to be, okay? And how to prevent it from going wrong. Because exactly like you guys said, right, is to make sure that an innocent person doesn't go to prison. Okay, so with that said, I think Mr. Villarreal told you guys what this offense or what this case is about. The allegation in this offense is aggravated assault with a deadly weapon, causing serious bodily injury on a family member or somebody with whom Mr. Trevino had had at that time a dating relationship. Okay, that brings up all sorts of questions. Okay, but the first one is just based on that offense alone. Okay, and I'll get into the details a little bit later, but just based on that offense alone, the experiences that I think everybody shared here earlier, knowing people that had been arrested, knowing people that had been accused, knowing victims who went through that or similar offenses. Let me focus my question on the first one is because of the offense, because of the indictment, is there anybody here who is just biased or prejudiced against Mr. Trevino in this case? No? Okay, all right. Yes, ma'am, number 29.
I think I'm biased because I was raised in an abusive household.
Okay.
So.
Oh, I'm sorry. Could you speak up just a little bit?
I said, I feel that I would be biased towards this situation because I was raised in an abusive household.
Okay, thank you for that, 29. Let me remind you guys, I'm so sorry, I forgot this. There's no wrong answer, number one. And number two, thank you for sharing that. But number two is if there's something personal to you guys and you don't want to share it, just let me know, raise your hand or raise your number and say, hey, Alfonso, I'm biased because of my reasons. We can talk about it if you choose, but we don't have to. Okay, I just want to make sure you guys know that before we go any further. So thank you for sharing that. Number 44.
I'm sorry, ma'am, you need to speak up. I would also advise.
Okay, thank you, ma'am. Number 50. Sorry about that.
I would also be biased.
Number 52. Thank you, ma'am. Number 37.
Yes, I would be biased.
Okay, thank you, sir. Number 16. Okay, number 30. Yes, ma'am, thank you. 65.
I will be biased. I've worked within the Texas criminal justice system. And we are taught not to judge people on their offenses when we look them up in the system.
Yes, ma'am.
So
65. I think you're working the Dominguez unit, right?
I do.
Okay. Thank you for that. Numbers over here, number 13.
I would be biased, my daughter was abused by her boyfriend.
Okay. All right. Did I miss anybody else? No? Okay. Thank you guys for sharing that. I really do appreciate it. I know it's a very, very serious topic, and it takes a lot for you guys to share, so I thank you for that. Okay. So the judge talked to us briefly, in being a juror, right? One of the rights that we all have, the Constitution is, the right against testifying or remaining silent or against self-incrimination. Do you recall the judge talking about that earlier ago? Okay, and she went ahead and gave you some explanations such as, language barrier if you're speaking in public. But in addition to that is everybody here, right, under the Constitution, we all have a presumption of innocence. Have you guys heard about that? Right? Who can tell me again, what is a presumption of innocence? Sort number 60.
Innocent until proven guilty.
Innocent until proven guilty, right? So, yes, that's correct. So what that means, right, is that right now, Mr. Trevino is innocent. Okay, he's innocent. And that presumption of innocence lasts the entire trial. Okay, so that means that after the state puts on their witnesses, right, I can choose to either just remain on the table with my feet on the table and not put anything as evidence. Okay, and that presumption of innocence is by itself alone is enough to find them or to keep them not guilty. Okay, so that takes me to my next question. Is knowing that there's a presumption of innocence, okay, knowing that everybody here has a right against nation, testify. Is there anyone here who says, you know what, Alfonso, those are the rules, but in this kind of case, I just need Aaron to testify? Is there anybody who needs Aaron to testify in this case? That's fine, sorry, is that number 6 or number 9? Number 9, right? Okay, number 9. Okay, anybody else on this side of the room? Number 12. Thank you, sir. Front row. No? Okay, going back, let me get y'all's numbers. We have 44, 51, 54. On this side, we have 59, 57. Anyone else? Okay, thank you, guys. All right, so moving along, another important reason why we need a fair and impartial juror is because remember, in a criminal case, right? In a criminal case, the state of Texas has the burden of proof. Which now you look at it, you think about it, oh, yeah, well, that's right. Well, presumption of innocence, doesn't have to testify. So yeah, of course, these guys have to prove guilt beyond a reasonable doubt. Okay, that is the highest burden on the land. And just to give you all some examples, kind of touching up on what the judge said, go to the other courthouse, right? And you hit someone and they're suing your insurance company for $1 million. If it's a commercial policy, $1 million, probably more, okay? The burden of proof in that case is preponderance of the evidence. Tip the scales 51 to 49. If your lawyer does that and the jury finds in your favor, you win $1 million. So think about that. That's $1 million, probably more, sometimes less. All right. Then the other burden of proof that people talk about all the time is clear and convincing. Okay. But now we have $1 million, 51 to 49 proof, burden of proof. Now the clear and convincing burden of proof comes into play, right, when the state of Texas wants to take your kids away, right? When they're saying, man, you're such a bad parent, neglectful, there's abuse in the house, there's drugs in the house, we're gonna take your kids away, right? So in taking your kids away, all right, the burden of proof there is clear and convincing evidence, okay? So it's higher than a money judgment, okay, in taking your kids away, okay? Now put that into perspective, because now on the criminal side, Okay, when you're taking somebody's liberty away. Okay, that is the highest burden of proof. It's beyond a reasonable doubt. And again, this is why a fair and impartial jury is needed. This is why I'm asking you guys these questions, because we're talking about taking somebody's life and liberty away. Okay. All right. This book right here, this is a 2022, 2023 edition. But make no mistake, this book was written a very long time ago. And it uses words such as biased and prejudiced. Okay, and those are words, they had a different meaning back then. Now they've all, those, that phrase in particular has another meaning, another connotation that most people are, it just sounds bad. Okay, somebody who's biased or prejudiced. The way I like to talk about it is just, you know, somebody who's just not in neutral. Okay, you know what? I'm not in neutral, right? If this was a death case and said, hey, Alfonso, could you be a fair and impartial juror? I would say, no, man, I can't. I'm not in neutral, right? Because several years ago, somebody broke into my house, right? And so, yeah, I wouldn't be fair and impartial. Okay. And that's because, again, because of life experiences. We all here have life experiences. So when you're part of the jury, your life experiences, when you were born, when you grew up, your childhood, your family, all those experiences play into your decision, okay, on this jury. All right. For example, not too long ago, Super Bowl Sunday, right? The call that had everybody in Philadelphia upset, the holding, right? Everybody said, that's not holding, man. That's not holding. But everybody in Kansas City said, oh, dude, come on. That was holding on your mom, right? And so why do those two cities in the Super Bowl, why do they have different points of view? Just anybody, why do that, juror number 20, why do they have different points of view on a holding call?
Because of who they want to win.
Exactly. Yeah, because of who they want to win, right? Because of the life
With the
experiences.
outcome.
With the outcome, right? And so now bringing it back to this case, right? Who you want to win, life experiences, whether you're a neutral or not, that leads me to my next question. And is this, the state in talking about the offense, you know, mentioned to you guys that we have a female victim, okay, in this case. All right. I think we've all heard some experiences that you'll have. I wrote them down. But the second question is, because we have a female victim in this case, all right, and knowing that some of you guys raised your hand by saying, hey, I'm biased and prejudiced against Mr. Trevino, but since there's a female victim in this case, is there somebody who says, hey, man, there's a female victim? I'm sorry, Alfonso, I'm already biased and prejudiced against your client because there's a female victim in this case. Is there somebody who feels that way? Okay, let me write y'all's number down. So looking to my left part of the room, any numbers on this side? No? Okay. Looking over here, we have number 37, 34, 38, 40, 51, 52, 54, 57, and 70. All right, thank you guys. All right. The other question, I think there was some people on this side who talked about it with the state. And I think it was, if I'm not mistaken, is it man number 15, right? I think you brought up the good example about you having some difficulties in that you would need more than one witness, correct? Okay. All right, now keeping that in mind, okay? And this is for you and then for everybody else. Is that because you would need to hear from other people or other witnesses on this alleged offense?
Due to my Christian belief. And just go with that he said, she said
Okay,
type of situation and make a decision. I need to have more than that. I need scripturally, I need at least 2 witnesses.
okay. All right, thank you for that. And this is, let me just put it blunt. Has anybody here heard of just false accusations? Right? Okay, I think we can all agree that there's just false accusations, right? Does anyone here know of someone, family, friend, relative, who's been falsely accused of an offense? Again, just raise your number if you have, okay? Number 24, you know someone, ma'am, that's been falsely accused before? Okay, number 20 as well, 27, number 11, 75, okay. Juror number 75, I'm not gonna ask you about the details, but in your opinion, why do these false accusations happen?
Just 1 second. So make sure you stand. Oh, you guys already failed that test, but that's okay. But make sure you stand and just remember to speak up so the court reporter can hear.
Because somebody could want revenge on another person.
Okay, revenge on another person. Number 24, why would a false accusation be made?
Could have been that one person making that false accusation.
Okay, thank you. Number 20, did you raise your number as well, ma'am?
I did.
Number 20, why would a false accusation be made?
It could be someone that's talked into it. Or just because you know, your friends or your family could be just.
Okay. Number 51, yes, sir. That's identity. What about, I think everybody here is, what about people that just are looking for attention? Right, and false allegations happen because of people looking for attention. Okay. Number 58.
After the criminal case, somebody could be looking for civil charges and against for financial.
Financial gain. Okay, very good. Number 53.
Anger or hurt.
Anger or hurt. Okay, you mean like in a relationship
Yeah.
or like a breakup?
Yeah.
Okay. All right. In analyzing or in determining whether an accusation is false, what would y'all look for to decide whether an accusation is false? Number 60, right? What did you number right?
Yes.
Number 60.
I guess the demeanor of the, if there's not any evidence really against, that would sway. the jury.
Demeanor, okay,
Demeanor.
no evidence. Thank you for that. Anybody over here, what would y'all look for to determine whether an accusation will be false? Number 72.
Every situation is different, obviously, if we're hypothetical. I would expect a little bit of detective work on the responding police to kind of put together what they saw in some kind of reasonable explanation. And if they can't work that out, they're on the scene, assuming the cops showed up. I would, if their story didn't really add up, I would say there may not be credibility. If there's a medical event that occurred and there's obvious physical damage, then I just gotta kind of take that into consideration. So it's not the words, it's all of the evidence you guys are gonna bring. That's what I think.
All right. Thank you for that. Anybody on this side? No, and then over here, what kind of evidence, what would y'all look for to determine if somebody is making a false accusation? Number 6.
Story.
Story changes, okay? For that, anyone else? Number 17.
I think it would be past history as well, because your history can tell a lot about as well as.
Is that the past history? Okay. Story changes time. Thank you for that. Can I see a number over here? No? Okay. All right. One of the allegations, right, that the state read to you was, causing serious bodily injury. Let me ask you guys this, can somebody injure themselves?
Yes.
Right, okay, okay. That's all I need to know. All right. All right. Just a couple more questions. I know I talked about it, I just need to make sure, there's a presumption of innocence, but is there anyone here who just says, you know what, also, I'm sorry, my neck, presumption of innocence, all that stuff. But I think Aaron is guilty because he's sitting here next to me. Is there anyone who believes that way, that Aaron's just guilty because he's sitting here next to me today? There's no wrong answer, just I just need to know. Okay, before. Sorry. Sorry. All right. Oh, yeah, that's right. All right, thank you, man. Anybody else on this side? No, okay. On this side, anyone who just says, hey, Apostle, yes, I get it, presumption of innocence, but he's sitting next to you, he's got to be guilty. No, okay, and then finally over here. No, all right. Okay, all right. Anyone who's just not in neutral, who just says, hey, man, you know what? I'm just not in neutral. I'm not. No? Okay. Thank you guys for your time. Thank you for your 54.
Yeah, I'm not.
You're not? All right. But I think I got y'all's numbers before, so 450. Okay. Anyone else? The numbers I didn't get. Let me see if I have you ladies. 16, I have you. Number 14. Thank you, ma'am. And 14, you're just not in neutral because you're biased against.
No, I think it's more back towards the question about a female being involved.
Okay. Thank you for that. I really appreciate that. Anyone else? 52. Yes, ma'am. I think I have you already. Okay. Thank you for that. 7. Thank you. All right. So thank you guys very much. I'm done. I think we should be done in a couple of minutes. Thank you.
All right, so ladies and gentlemen, I'm going to have you all step outside. I need you to take all of your personal items with you and leave the expensive parts behind. So if you all will wait out in the hallway for us, please.
No, they stopped the board there.
innocent until proven guilty.
Okay.
I'll vote.
Okay. So that's
It's
what-
new to me. Be as neutral as I can.
All right, any other questions? All right, thank you so much. You can step outside. And I'll hear you, your arguments after we finish with juror number 65.
Yes, Your Honor. Juror number 65, Ms. Davis, correct? I asked a question, Ms. Davis, about bias or prejudice to the defendant in this case, raise your jury card. So I think you said you're working in the Dominguez unit.
Yes,
So you already have that bias against the defendant, correct?
pretty much.
No further questions.
I'm just hoping I'm not understanding this. So as far as the bias is concerned, like the judge asked the previous, when I remember. Are you saying that you would insert your history in working at the Dominguez unit? The correctional facility. Into the deliberations, or would you be able to just base your judgment and verdict based on the evidence received from this courtroom and the law that the judge is going to give?
It will be my history.
Okay, no further questions.
All right, thank you. All right. The court will hear argument with regards to 14. Are you still asking that 14 be removed from cause defense?
14, Your Honor, the defense is still asking a charge for cause of 14. I think her answer varied. She left by saying, I'm trying to remain as neutral as I can be. But I think we all three of us realize that she's not neutral, she's biased against the shooter.
All right, state.
Her answer was clear and unequivocal when the court inquired, and so I think this is not improper for a challenge for cause. Then I'll, base my verdict on that testimony in the laws.
All right, defense's request for cause on number 14 is denied. With regards to 65, any objections from the state?
No, Your Honor.
All right, number 65 will be granted for cause.
Thank you, Judge.
All right, so
Jump out, run.
Just get all the way to the edge, please, all the way so it could be easier for other people too. Because not everybody's gonna get a chair. Just all the way to the edge, doesn't matter. No numbers. Like all the way to the edge, all the way to the edge. No, they don't have numbers. All the way to the end. Anywhere, just. Anywhere. Now, all the way to the end.
Walk right in front of you.
Just check up here. Anywhere? I think this one's. Always good. Not everybody's gonna have a chair, so that's what I'm telling you, just pick a chair, stand on the first row. First row, right here in the bench. Hold on. That's the last spot. And everybody else, just come on in, just have a stand.
All right, everyone, please be seated. Those of you who have a chair. All right, I want to thank you all so much for your service. Again, as I previously stated, we cannot have jury trials without jurors. Each of you should have one of those white sheets. Do they have the white sheet, Deputy Laura?
They may not all have them, but Mejia's back there with extras.
All right, Mejia's in the back. Deputy Mejia, when you get ready to leave, everyone, Deputy Mejia will give you one of those white sheets to signify that you were here today. Now, when you go downstairs, how are they going to do the parking validation?
Well, if you did not get your parking validated, make sure when you leave the parking garage, you leave closer to the booth.
So that you can let them know. So, and just let them know that you were in jury duty in the 187 District Court and you'll still get the parking discount. Now, you can donate the money that you'll receive for being here. And there are many organizations you can donate that to. Otherwise, what will end up happening is at some point, probably 3 months from now, you'll receive a check in the mail and you will say, is this real? Is it not real? And then you'll remember the great time you had in the 187 District Court with Judge Boyd, and you'll say, oh, it's real. I always invite everyone to come down to the courthouse so you can see what happens in trials. All the courtrooms are open to the public. I just discourage people from going to the juvenile court or children's court because those are very sensitive matters and it's not adults who are in those courtrooms. All right, with that being said, I'm going to call the persons who are going to be on this jury. And when I call your name, please take a seat in the jury box so that I can give you instructions as well. Jose San Juan. Mario Lopez.
Who?
Mario Lopez. Samuel Hernandez. Sabrina Sanchez. John Ramirez. Deborah Benavides. Billy Klassen. Maribel Defritas. I know I mispronounced your name. I'm so sorry. Susanna Romero. Angel Gutierrez. Crystal Tovar. Yeah, let me go back. That's one. Okay. Harold Pettis. Thank you. Sean Leroy. Daryl Rasleben. All right, so everyone else, you are excused. Deputy Mejia, if you, hey, don't rush, don't rush. All right. Deputy Mejia will give you your card if for any reason you don't have one. All right, ladies and gentlemen, thank you so much. When you report to this courtroom tomorrow, you're not going to report here. You're going to report to the jury room, and Deputy Laura is going to show you where that jury room is. From here on out, if you need to communicate with us, you'll need to do it through the deputy. So when you see attorneys for the state or attorneys for the defense or the defendant, and they're not saying hi to you, if you say good morning, it's because they're not allowed to. It's not because they're nice people. I mean, not nice people. They are nice people. It's late. All right. The other thing is the temperature in this courtroom fluctuates. Sometimes it's cold, sometimes it's pleasant. Usually it's very hot. So it's better to bring a jacket. As I always say, and my mom always say, it's better to have it and not need it than to need it and not have it, because we don't have any extra jackets for anybody if it gets too cold in here. You are allowed to bring drinks in, but make sure there's a cover on it because we try to avoid having spillage. I don't expect this case to have any publicity or anything of that nature. But if you see something or hear something on social media, or somebody wants to talk to you about this case, just walk away. Do not discuss it with anybody, because everything you need to know about this case will come from inside this courtroom. Do not do your own investigation. Again, everything you need to know about this case will come from inside the courtroom, because everyone wants it to be a fair trial. Any questions? All right, so we're going to start tomorrow at 10 a.m. Here's the thing about starting at 10 a.m. We're starting because I do have a morning docket that I need to take care of, and I'm going to do a hard stop with them at probably 9:55, so you all can be here at 10. We cannot start this trial if everybody is not here. So if somebody is not here, then what will end up happening, we'll wait for you. If there's some sort of emergency that has occurred, Deputy Laura will take your information and tell you where you need to call and who you need to call. The parking garage, let's discuss that. The powers that be who built that garage didn't take into consideration that everybody who works in this building is using that garage. The fact that I think some federal employees have access to that garage as well. And also the fact that we get probably 200 to 300 jurors down here every day, aside from you all who are trying to get parking space. So even though we're starting at 10, if you want to get a parking space, you probably need to be here before 9 a.m. Now in the jury room, there's a refrigerator back there. You can bring your food, your lunch, whatever you would like to bring to store in there, and nobody will bother it. So that will be all. Any questions? All right, then. Sure. All right. So we'll see you all here tomorrow at 10. All right, everyone, please rise.
Follow me, please.